Was this a business or what was it?
It's an abandoned warehouse yard. And like they indicated that everything had no trespassing sign, everything is boarded up, so nobody would enter.
Mr. Rodriguez, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You're ordered not to go back to this location. You have already missed court once. If you ever miss court again, there will be no more PR bonds for you.
Am I
You
able to
understand?
speak?
Don't. It's not necessary. You have the right to remain silent. You need to exercise that right. I've got DAs here. Whatever you say, they're going to sit there and they're going to use it against you to try to prove your guilt. So it's best not to say anything now. We can talk about trying to get you a lawyer and you can tell what you need to say to the lawyer. But whatever you say now, they're just going to try to use it to prove your guilt.
Okay, because some of that.
Stop. Don't.
Gotcha.
Just don't. It's not a good time right now. At some point, you'll get the opportunity, but just now's not the time. Tell me, how do you support yourself, ma'am?
I'm homeless. Right now I'm in a shelter, because I was in a relationship, that's why I was able.
Hold on. All right. So I'm going to appoint you a lawyer today, but why are you not working?
I was in an abusive relationship, that's why I missed court. Why am I not working? My mom stole my 2 kids about 5 years ago and I got sad. So I was,
So mom, is mom around now?
she said she could take me to court.
No.
So,
No. Ms. Rodriguez, why not live with mom
she doesn't
instead of
want me to
living on
be
the
there.
street?
She won't, maybe if
Isn't anything better than living on the street?
I want to live with my mom, but she says I'm not ready and I don't know what she means by that. I would love for y'all.
So here's what we're going to do. As also the condition of your bond, I'm ordering you not to use alcohol or illegal drugs. And I'm
Okay.
going to test you. If I find that you're using illegal drugs, including marijuana, then likewise, I will revoke your bond and put you in jail.
Okay,
You know, the chances, Ms. Rodriguez, is that I don't know who you have in this life, but if I revoke your bond and make it 5 to 10,000 and you don't have anyone to put that money up, you will be stuck with me for who knows how long. It takes 6 to 9 months just to get a 911 call, and you can variably sit there for who knows how long. I'm not asking much from you. Don't use alcohol. Don't use drugs. We have resources for you. If you need anything, all you need to do is ask and we can try to help you get whatever you need, but you understand?
Mhm.
Okay, I'm going to have you sign a reset. I'm going to have you take a seat in the jury box while we find your lawyer. Okay,
okay.
please. Good morning, Mr. Petoniak.
Good morning.
Happy Wednesday.
What's that?
What's up?
Good morning, Mr. Fleischer.
You all right?
Yeah, I'm okay.
Yeah, cool. Yeah, have fun.
Yeah. Oh,
Is it old?
I'm being told I need to approach.
Who is it?
Silver nail.
Where's Mr. Silvernail now? Come up, Mr. Silvernail. I'm sorry, Mr. Petoniak. But it has come to my attention that you've not picked up yet another case. You now stand charged with violation of a protective order. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
June 14, law enforcement responded to a welfare check in Harris County, Texas. When they made contact with the complainant, she was visibly shaken. She indicated that the defendant knocked on her door and said that he had been in a motorcycle accident and needed medical attention at 1:30 in the morning. Defendant entered the residence and was ordered to leave by the complainant, but he refused. He entered her bedroom and attempted to hold and hug her while she was covered in a blanket. The complainant advised that the defendant did not want to let her go and was trying to force her to hold him. Did not leave until complainant contacted law enforcement. She began receiving messages from him in which he threatened to cut off his arm, which he had previously injured earlier in the day. The complainant advised that she had obtained a protective order against the defendant on April 29, 2026, and he was identified by his driver's license. Officers confirmed that there is a valid protective order currently in place for this defendant, prohibiting him from coming within 200 feet of the complainant and the residence where he was located. The protective order further prohibits him from engaging contact directed towards the complainant that is likely to annoy, harass, and abuse and harass her.
Okay. So we did order him not to go back to this location, correct?
That's right. He has currently an open harassment charge. I'm sorry, that one was dismissed 6-4. But he does have a protective order in place. We do have that. And then he had that deferred for the assault family member that he pled to in 2024. I was double checking to see if it was still in place.
I don't think a motion's been filed on that yet.
Yeah, no motion has been filed, Judge.
Can you-
Last time.
It has been filed.
It's in your queue.
Okay. There you go.
I'm s- I'm s-
Because last time he was here was 6/4/2026, where we amended his conditions of community supervision and extended him from 1 year on 6/4/2026. And this charge happened
Mr. Silvernail,
6/14/2026.
I'm now signing a motion to revoke your probation and a warrant will issue as of this very moment. And let me tell you something, and I want you to hear me loud and I want you to hear me very clear. The Texas Constitution does not allow me, but in extremely limited circumstances, to have a hearing to hold you at no bond. You are now at that stage. You are charged with violation of a protective order. If I put conditions on you now, you violate these conditions, within 3 days, I can have a hearing to hold you at 0 bond, and I will do it in a heartbeat. A felony choking case, a harassment, you're on deferred for an assault, and now you've picked up a VPO. The next step is you violate conditions I put on you now. I will have a hearing to hold you at no bond. Do you understand me?
Yes, sir.
As it stands now, you are going into custody at this moment. I'm filing a motion to revoke your probation, and now we will have a hearing to determine if you violated your probation. So
And Your Honor, he made a $20,000 bond on the new case. He does have a bail bondsman on the way up.
I'm not, no, I don't care. This is the 4th case against the same complaining witness. He's on probation. There's a protective order, and yet it's over and it's over. Clearly, there's no non-financial conditions we can put to ensure that he's not going to violate conditions.
He does have an ankle monitor on this morning that he was in custody for 2 days when he picked up this case. So he was arrested Sunday or Monday. He made bond yesterday. So it was 2 solid days. He does have an ankle monitor on now. So considering the high amount of the bond he has already made and that the ankle monitor is in place, I would ask that he be permitted to walk through the bond, or a bond is set.
The bond is set at 10,000 now. On the motion to adjudicate.
Understood.
Well, no, has he violated conditions before?
So when he was placed on the deferred originally, we took that plea 5/21/2024. He picked up that harassment charge.
Yeah,
And so then we dismissed the harassment.
I'm sorry. While he's on probation, he picks up a harassment case. And we were working toward finding a resolution to be amenable to everybody. And now he's picked up another case. I'm not going to let him do a walkthrough. It's not reasonable. You know what I mean?
Understood.
It's the second time he's picked up a case while he's on probation for an assault.
Understood, Judge. So the bond amount is $10,000 on the motion to adjudicate.
Yeah, what's reasonable considering everything?
10,000 is reasonable, Judge.
It's 10,000 now.
So
That's what he picked up the first case. It was set at 10,000. Now he's picked up another case.
So, Judge, in light of the fact that he already made a $20,000 bond on the new case, would 15,000 be reasonable?
Judge, honestly, I fear complainant.
Really, we're just not getting through to Mr. Silvernail. Mr. Silvernail does what he wants to do without regard to. He could, just because he has an ankle monitor, doesn't restrict him from going to the house. He could theoretically leave here, go back to the house. And that's the fear that I have. He does whatever he wants to do, to hell with the bond conditions, and not 3 cases, 4 different times in custody have made a difference, you know?
I understand there was a lot that happened in the past. I've communicated the expectations of the court with my client, and he stands ready to comply with your expectations as stated.
But
Judge, I can say that it looks like he pled on 4/10, picked up that charge, he pled in 2024, he picked up that harassment on like 3/30/2026. You amended his conditions to extend it for a year on 6/4, and we're back here 10 days later on a new charge.
I'm setting your bond at $50,000. I don't know how else to get it to really have you understand how important and how meaningful bond conditions are. Everything that we've done today, really 10 days later on yet another case. As much as I love you, Mr. Petoniak, the problem is it's not you, it's him. And we're now yet again, 10 days later. I really have I mean, I really truly don't think that there are any non-financial conditions. And let me tell you, I told you, Mr. Silvernail, if you go within 1,000 feet of where this person lives, works, breathes, I'm going to have a hearing to hold you at 0 bond. Do you understand?
Yes, sir.
You were not to consume alcohol, illegal drugs. Do we know if alcohol played any part?
She did not indicate, Judge, that she was impaired on this occasion. Let me just double check the other ones.
I mean, do we put a device on his ankle?
There's one.
No, a scram. Yeah. Because I don't know if drugs or alcohol are playing a part in the choices that are being made, you know? A lot of people seem to make choices when they've consumed, and I don't know if that's part of the issue.
Judge, she did not indicate anything relating to substance abuse. She did indicate that he had PTSD, which causes him to be emotionally abusive and angry, but nothing in relates to any drugs or alcohol or anything like that, Judge.
My client indicates he's a teetotal.
So what?
Teetotal. He doesn't drink.
Oh,
There's not been no indication from
I
that.
mean, I'm still going to order just no consumption of alcohol, no consumption of illegal drugs. You're going to be tested on a weekly. I don't know if you're going to bond out, but if you do, you'll be tested weekly so that we know you're not using. And do me a favor, let's fast track this because I'm now going to set you for a hearing in 30 days on this motion to revoke your probation. And we're going to decide you're looking at a year in jail. Do you understand? But when we have cases that are entirely way too much drama, the longer we wait, the worse it is for all the parties involved. It's just, so please do your diligence to get everything as quick as possible, and then we'll go from there. He goes with you. Nick, I'll talk to you in a second, but I want him to go back.
Yes, sir.
Can we go back?
Yes, sir.
Come on.
I'll get with you in a second.
Nathan. Karina. So he just did a TRS. So about almost a month ago.
The MHA, is that what it was for? Right?
They recommended Veterans Court.
That's why.
But what I'd like to do now, in light of the new case, would they make any different recommendations? So she can ask them to just look at it. You've got it done. He's picked up a new case. Would you make any different recommendations in light of the new case? So we don't have to go do a full-blown TRS again.
Understood.
So I'm just going to ask them if there's anything. Yeah. Let's just see what they say, and then
Right now, at the moment, no, but.
I guess we'll see what they say.
A different shelter, because I'm getting.
So I'm going to order though that a GPS prior to release
I might want to take vacation.
Should we put a scram or no?
Didn't even really get on.
If they say
No.
the same judge, it's not alcohol related.
Okay. So just a scram prior to release, not to go within 1,000 feet of where she lives, works, no weapons.
There's no way for me to do all
That's
that.
it.
So then.
I don't even think there's a
Y'all have
way
this
to
screen
call.
first? Okay.
So I don't know why
Yeah,
they're asking.
they're gonna run it.
What's that?
They're going to do,
Yeah.
yeah, okay. It is what it is.
Make his.
Right, but just let them know the next time it's going to be an issue. If he violates conditions again. And I don't know, I mean, maybe we should order some kind of treatment in the interim, you know?
Yeah, he is on probation.
Judge, are we gonna hear anything on him? I'm not sure what his job is.
What
He
does
has
he
his own
do?
business, he's a roofer. So he is a pretty demanding.
Oh, no, but I just don't want him out in the middle of the night. So maybe like a 10 PM curfew. It happened at 1:30? Oh, well, thank you for telling me. No. Now he's got a curfew.
Right.
10 PM to 6 AM.
Understood.
Yeah. So, and then I'll let her know. I'm glad you told me that. I had no idea. I mean, that's,
Okay. I wonder, I didn't see him back.
we're gonna, they'll probably just put him back. We'll bring him out because he needs to sign new conditions anyway. So we're gonna bring him out to sign conditions and then we'll go from there.
Okay, great.
Yeah,
Thank you, Jeff.
thanks.
Order of probation call for hearing this.
No, let's, you know, if it's a mental health issue, then we need to find, you know, I mean, I don't know. No, I would say no at this point.
Okay.
All right. Good morning, ma'am. Ma'am, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am. Okay.
Officers responded to a call for service that changed into an assault family member. Complainant stated he was assaulted by his ex-girlfriend defendant. Complainant stated defendant was identified by his driver's license text him throughout, and threw his clothes out. Complainant's clothes were soiled with feces and barbecue sauce. Complainant went to get his clothes and defendant punched him. The state said the defendant used both of her hands and grabbed his left arm between his shoulders and his elbow. Complainant stated that the defendant then grabbed his face and used her thumbs to try to gouge both of his eyes out, but was only able to gouge his left eye with her right thumb. Defendant then used a closed fist and struck the complainant on the left cheek with the right fist. He felt pain and wanted to pursue charges. When officers attempted to talk to her, she said, "Go ahead and just file charges."
Do we know, is there a serious bodily injury?
The only thing that said, Judge, was that she punched him and he felt pain.
Okay, well, and the eyes gouging out,
And that is all, Judge.
allegedly. Do we know if alcohol or dope played a part in any of this?
No, Your Honor, I don't see anything.
What time of day or night was this?
Involved.
Does it say?
The officers were dispatched. I can check. She just got the offense report uploaded. Officers were dispatched at 5:13 PM.
Okay, Ms. Williams, I'm going to find that there's probable cause to go forward with your case as a condition of your bond. You're ordered not to have any contact with this complaining witness at all by any means whatsoever. It does not matter. There's a protective order that has been issued and you need to get to know it. If you violate the protective order, the state can and probably will file a violation of a protective order against you. It's one of the worst cases you can pick up. You saw what happened earlier, right? Just, I'm not asking for much. I'm going to protect my community at all costs. I don't care who you are. Just you violate conditions, I'm just going to put you in jail. It's not a revolving door. There will not be PR bond for PR bond. Do you understand, ma'am?
Yes, sir.
You are not to go where this person lives, works, and when I mean no contact, I mean no contact of any kind. Text messages, phone calls, emails, going to the house. If he should reach out to you, you still can't have contact with this person. It's still a violation. If they call you, do not answer. If they call you from an unknown number, hang up. If the person should text you, do not reply. You're the one that will end up in custody. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them and they'll tell you if and when you have to come back to court. Also, no weapons. So for now, I'm going to have you sign a reset. Then I will have you take a seat in the jury box or we'll get your bond conditions. Once you sign them, at that point, you'll be free to go. All right, please. Yeah, no contact, no weapons, and no going to where they live or work, please.
Sure.
Ally,
Good morning.
hey, good morning.
I am checking in on Joshua Alexander. It was a required appearance today. I had heard he had not checked in. I was able to get a hold of him and there was some confusion about what day he needed to be in court. Can we roll him to next week? Ordinarily, I would say come downtown real quick, but it's a little crazy downtown. So I'm wondering if we can get rolled to next week.
I don't know. Let me see. Have you had any contact with him whatsoever?
Yes, I got in contact with him this morning.
Okay, so I mean, I guess we will set it for bond forfeiture for, you're at 180 days. It's time to do something. So let me make sure
Yes,
that.
Judge, I got an offer this morning.
You did get an offer? Okay, so we'll set up for bond forfeiture for Monday or Tuesday. You pick it and he's got to come, he's got to accept, or we set it for trial.
Absolutely. We will be there. Thank you so much, Judge. I think that's all I need to zoom in on.
What day do you want, Ally?
Tuesday is a little bit easier. I'm supposed to be picking a jury Monday and
Sure. No,
two.
Tuesday.
Okay, perfect.
Yeah, Tuesday, whatever you want. I don't care.
All right. Thank you, Judge.
Okay, all right, we'll see you Tuesday.
Thanks. Bye-bye.
Okay. So just, if we can make a notation that he failed to appear today, so that's SFBF. So if he tries to, again, he doesn't appear. Okay, Justin, you ready?
Yes, Judge. Mr. Robinson. Mr. Robinson, we have a, he's here, we want to see if we could trial. State's going to afford us with issue are.
Sure, but understand though, that if it's 90, it's 190 days old. If we set it, great, but this is the plea bargain deadline. If he doesn't want to do anything after this point, we'll set it, we're going to go. Okay, I don't want to just, like, I don't want to set up a trial and then, all right, well, we're going to plead guilty on the day of trial.
Oh, no.
No. If we set it, we are going to go.
Yeah.
So,
But we-
Mr. Robertson, come up.
Or they can dismiss it, right?
Sure.
Okay.
Yeah, I mean, that's up to
They
them.
brought up an operation issue, I think that you guys will evaluate the operation issues, so.
Do you want to wait till maybe next week to see if they even kick it instead of setting it?
Can you only do it in a week?
Yeah.
Could you waive his appearance for the next one?
Sure, but if we set it though, I mean, next week will be the plea bargain deadline though.
Sure.
Like he'll have to either accept it.
Okay. He's just wearing on him getting down there. He's lost his.
I understand. No. I understand. I get it. Unless there's something which he wants to take, then he's got to be.
Oh, sure. No.
Yeah, I'm okay with that, Justin.
To do that, but
So,
if we,
If he doesn't, then I'll just let him.
if we do it a week for them to eval, we can waive his appearance.
Yeah.
If they're not satisfied, we can give a trial date next week.
sure,
Okay,
but that's the plea bargain deadline. If he sets it, we're going to go.
understood. I got it.
Like, I'm not going to, okay, well, no, we want to, at 250 days, we're going to try to plead. No.
Okay,
We set it, we are going to go.
And when we see he's okay with.
Yep,
one month
sure.
For the state. What's it?
Good morning, Miss Lewis.
Good morning, Judge.
What's up?
I have Nicholas Rogers on your docket, Your Honor.
Rogers.
Yes, sir.
Okay,
So on Mr. Rogers, Your Honor, we're actually currently in a murder trial in Nashville. So I just stepped out to do the Zoom. We just need one more setting. I think this case could be disposed of pretty quickly. We do see an offer in the system. We just hadn't had a chance to meet with him because we were preparing for this trial.
is Mr. Rogers here now? He's supposed to be here. He didn't check in.
That is a problem. Let me call him and figure out.
So let's do this.
Okay.
Your case is 180 days old. It's time to figure out what we're going to do. So I'll give you 2 weeks. But at
Well-
that setting, the next setting is plea or trial.
Okay. Your Honor, we will be back from trial. We start actually on Monday. We did a pretrial conference this morning. So it's supposed to last about 2 weeks. So I'm just trying to see if we can do
You want to come earlier?
the first week of July.
Do you want to come earlier? I mean, so when do you start trial?
We start trial on Monday.
July 6th.
Okay, July 6th, but that's the absolute final day. There's no
Okay.
more resets after that time because you'll be past 200 days.
Okay, and we just signed on, Your Honor. We hadn't been on the entire time, but I understand the course timeline.
But I
So-
guess, I get it, but nevertheless, we still gotta, so, not only that, I'm gonna set it for bond forfeiture. The defendant must be here at the next setting, okay? He has not appeared today. It's all right, but if he doesn't appear the next time, I'm gonna issue a warrant,
Okay, sounds good, Your Honor.
okay?
All right, thank you so
All right.
much.
Yes,
Have a good
ma'am.
day.
Take care.
Yes, Sean, can you hear me?
Good morning.
Good morning. Good morning. How are you?
Who are you here on?
I'm here on Juan and Campos.
You said Campos?
Yes, Your Honor.
Got it. So we just give you a reset, right? Is that all you want?
Yes, but I had spoke with the state. I sent over his insurance information. From my understanding, it's supposed to be provide proof of insurance and for dismissal. I just wanted to confirm if that was the
Who'd you send
the
it
state
to?
was able to. I have. Let me look at the email. I sent it to two prosecutors. I have a Sarah.
Okay, so here, I'm gonna send you an email of who to send it to because there's not many people here today just because of the rain and because of FIFA. So I'm gonna
Okay.
send you an email real quick. I'm gonna
Okay.
chat you an email if you don't mind sending it here. And this is to our chief.
Okay, sounds good.
Bear with me 1 second.
I don't know what that first is. The defendant's last name was Campos?
Campos, yeah. She said they sent, okay, I just sent it to you, Mr. Johnson. He said,
Okay, perfect. I have it.
Sarah, the insurance.
I didn't file.
I don't know if there was, if it was just insurance for the dismissal or something else.
Well, I don't see any plea offer, Judge. There's an FBI form, because he had a prior PTI for DWI. And I don't think we contacted the complainant yet.
Are you saying there was an offer of just insurance for dismissal?
I know in the first court setting, we talked informally just to send insurance, just to confirm they had valid insurance on the day of the incident, for dismissal.
That offer is not on the file.
I'm pulling up now. Just see.
Or maybe it will,
Yeah,
No.
yeah, the case. Okay, so they're saying that Ms. Farwell did, verify if he provides insurance, we can provide it to the complainant and we will dismiss it.
okay.
Out of the resolution.
Okay, thank you. And I just
So
forwarded
wait,
to,
restitution, did you need restitution? You don't need
So they're
restitution?
gonna go through the insurance, Judge.
Okay, all right. They're gonna dismiss it, Mr. Johnson.
thank you, Your Honor. Thank you.
All right, man, have fun.
You're welcome.
Thanks.
Bye-bye.
Do you want me to make? You ready to do it? Should I write it? Hola.
You're bringing them out.
Do you want me to make a docket notation, something like that?
Yeah, I'll say it myself.
I mean, this is not gonna have an impact. Will it have an impact on?
But it's also one of those things where I just. It's not, I don't. In depth with that.
I know, I believe, but do you want to wait to see if there's a global resolution?
I want it.
Do we know?
He just got indicted. Okay. And if she. No.
Do you know where it's headed, how long it's gonna be?
Okay, so do I know where it's headed? Do I think it's gonna be an easy one? I think it's gonna be work it out. So it's the question is like, should he drag this one out? Or should he set it on trial or do something, you know? But he doesn't want to do that.
I don't think that it's something that they're just gonna leave out, you know?
You want to bring her up or no? Are you grandma? Thanks for coming.
You can if you want to.
Shh. So,
He does want his grandma here.
okay, come on up. Hi, thanks for coming. You know, this is a critical time for you. The more convictions you rack up, just the more, you know, the more difficult life gets. I can never put my shoes or myself in your shoes because I'll never know what it's like growing up, you know, but your lawyer's advising that you wait because you're in custody regardless. You're being held on something upstairs. I mean, I don't think you're getting out anyways. And perhaps that you guys can work out a global resolution so that everything happens at once for the best for you, Mr. Robinson. When you take the easy way out, it just doesn't work to your benefit. Tell me.
Jalen, to my understanding from his attorney, went into a store and took some.
Well, wait, let's not talk about the case. I can't.
Okay,
Let's
well,
not.
anyway,
No, we
he
don't.
did wrong.
No, we don't talk.
So,
Don't.
he's guilty.
No, we don't.
Don't. So there's a bunch of prosecutors here. I don't want you to say
Well,
anything that's going to make it
anyway,
worse.
What my plans are for Jalen, once we get all of this behind him, he and I have talked about it. He's coming back to Louisiana with me. That's where he was.
I understand, but
He wanted to come with his mom and come out here and got into some trouble. So he's coming back to Louisiana with me. We have Delta Community College where he can get his GED. You got the community center, the community college, ICE facility, and our facility, all on one strip. I pass by it every day. I can get him there to get his GED. Once he finished that, they have auto mechanic, they have welding, they have nursing. There's something there that he can take. Right now, I'm not really concerned about his record. I'm gonna cross that bridge when I get to it. Right now, my concern is getting all of this behind him and get him out of Texas.
as the adage goes, you can lead a horse to water.
But you can't make him drink.
You can't make him drink.
Okay, but he's been with me all his life.
If you still get out to Louisiana, Abu Dhabi, wherever it may be, if you're still running with people who are getting in trouble, you know they're going to bring you down. It doesn't matter whether you're doing this, whether you're doing that. It's perception is reality. It always is, you know? Do you want to wait and do this to see if everything works out all at the same?
And so we have discussed, as you discussed at length, that there's a chance if we wait, that we can get this dismissed. And that would, hold on, I just want to make sure. And that would not infringe on him since he's still in custody for the felony. It's not like he's getting out.
Have you
I
spoken?
understand that,
I just want to,
but to my understanding, he can plead today
Yes.
and have time served.
yes.
Right, that's
But
what I want. That's what he wants. That's what he told me he wanted. So that's what we are going to do so we can be finished with this court. And I can move on. I got 5.5 more hours to go back. I left this morning at 4 o'clock to get here. Now I gotta go back to Louisiana.
Have they offered to dismiss both of these cases if something happens upstairs?
No. But do I think that it's in the world of possibility? Sure. Do I think they'll do it before anything happens on the felony? No.
Right. There's a possibility that, but understand, there's a possibility that if something happens upstairs, they may dismiss both of these cases. One of the cases that he has here is the theft case.
But I'm gonna still have to come back to Texas, to come back in here, to go back over there. This is a 5.5 hour drive for
But
me.
you don't have to.
Yes, he's not coming before anyone without me or his mother. No. No, I don't want that. Go.
Karina, on what is is there any headway that's happening upstairs? I'm telling you, Mr. Robinson, I'm telling you, I think it's a bad idea, man. It's not a good idea. I think you should wait. You can do whatever you want. You're the driver of this bus. I'm telling you, it's a bad idea and that you should probably wait because it may work to your benefit later on. Once you get a theft on your record and you're branded a thief, it becomes very difficult to get a job because people will make assumptions and they'll think things because you have that theft. I'm telling you, it's a bad idea. I'm happy to do whatever you want to do.
Okay,
But-
that's the route we can go.
So Judge, looks like the last update was grand jury packet was put together for this case and the grand jury indicted it
Yeah,
on the 6/2/2026, and that's the last update they have.
there's nothing else that's no offers either.
No offers yet. So it looks like there is, hold up, any notes, multiple co-defendants.
Right, anything happens. So I'll make a documentation, I guess.
Yes, I mean, that's all. And we've discussed, I think that the felony, while I don't represent him on it, we've gone through all the evidence, carry defensible, something that we can definitely work out a global deal on, I think, but I think Mr. Robinson will have to take this today.
And I know one of them, Judge, one of the co-defendants was offered on June 2nd, 8 years TDC. It looks like they were probably going to accept it, but for some reason, I'm not sure if he did. Or not, so the PV vote was filed, but it doesn't show like it was disposed of. So that was the last offer on one of the co-defendants. The other one doesn't have any plea offers, and this gentleman does not have any plea offers.
Do you want to wait or do you want to?
Wait faster.
You sure? Mr. Robinson, you're charged with evading arrest. You're also charged with theft. The agreement that you have worked out is they're going to dismiss the evading arrest for your plea on the theft case. This is a Class B misdemeanor. You're facing up to 6 months in jail and or a $2,000 fine. Understand that from now on, should you pick up any more misdemeanors here, you'll be looking at a minimum of 30 days in jail. You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. Once you plead guilty, you give up the right to appeal, meaning that once you plead guilty, you can never change this or undo this. You sure you want to do this? How do you plead to the theft? Guilty or not guilty?
Yes.
I'm going to find you guilty. I will sentence you to the 20 days in jail. I'll give you credit for the 113. I'm going to make a notation that this is against the advice of defense counsel. And that I have also admonished you as well. All right, best of luck to you, Mr. Robinson. Thank you for coming. Hey, are you ready? Hi, yes. Morning.
Miss Irma de la Rosa Vasquez.
Is this a new case? Okay. It's under Vasquez? Okay, I see it. All right, you are Miss Vasquez. Ma'am, you are charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Your Honor, officers were dispatched to a theft at Walmart in Harrisburg, Texas. Please look for the loss prevention officer who stated that defendant and two other defendants entered the store. Just a box of Huggies diapers and a drink. A box of Huggies diapers and a drink. Went to a Nissan SUV. Came back inside to the Walmart and began to conceal merchandise inside backpacks and their clothing. At this time, they passed all points of sales without paying for any of those items, which were total approximately $151.40.
Ms. Vasquez, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you're ordered not to go to any Walmart whatsoever for any reason. You are also not to have any contact with the co-defendants in this case. Do you know if the motion is going to be filed upstairs? She's on felony deferred?
Yes, I'm not aware. I haven't spoken to her. There's an emotion filed yet.
So you're on felony probation. It's very possible they issue a warrant for your arrest on that case. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with counsel. If you violate these conditions, I will order your arrest and I will put you in jail. You understand, ma'am? Okay. I'm going to have you sign a reset. I'm going to have you take a seat in the jury box while we get your bond conditions. Once you sign your bond conditions, at that point, you will be free to go. Thanks. Okay. No, wait, she needs to sign a reset first and then, yes. So if you don't mind filing, then no Walmart, no contact. Hey, please.
I'm here on Mr. Hicks.
Jail or bond?
Bond.
Okay.
Waiting on blood, chief is, I believe, gonna follow up on it. It's a hospital blood case. So for whatever reason, we still don't have the blood results on them.
That's not good.
Yes, so I'm double checking I have to go through everything. So it looks like it was a 2B filed. After they got the results, he was arrested on January 2026. That's when it was filed, January 16, 2026.
Okay.
It's officially filed. So they're indicating that they got the blood vials from the hospital, but they also sent it to HFSC. So I'm trying to see if, it looks like Barlow reached out. And I'm trying to see if she got anything back from them, Judge. I just haven't had any updates. I'm reaching out to our liaison as well to see if he has anything. I just don't see anything updated in our system.
I guess let's set it 2 weeks and let's see where you're at. And at that point, if you don't have it, we'll set it for a 10-day trial or for a discovery hearing.
Thank you, Your Honor.
Yeah.
Maybe
Okay,
it's-
you got it.
Thank you.
Manny,
Hey, Judge.
what's up?
Oh, no, I'm coming in on a McPherson.
Say it again?
I'm here on a McPherson, Judge.
Oh, McPherson. Okay.
Sorry, we had Montgomery County here in the morning, and I'm just getting to a place where I can actually.
Don't worry about it. Is McPherson here? Come up, Mr. McPherson. He's got bond violations.
Yeah, so that's why we're here today, Judge, is the BVRs. And we had sent a message to pretrial, or Sean did yesterday. We believe that the BVRs are missed blows, but we think they're out of window blows. We don't think he actually has a missed blow. I think they're all out of window blows, or at least most of them are out of window blows.
Yes, Judge, I had the report from the officer this morning, and so one was 8:44 PM, so 45 minutes late. Other one was 15 minutes late, an hour late,
An hour late.
2 hours late. $53 late.
It's unacceptable, man. This is not when you want to blow. It's when you're ordered to blow. You may live a life where people acquiesce to your every whim, but you're in court now, and that's not the way. You will now get a scram on your ankle, and there's no tolerance. You put anything in your body to make that go hot, and I don't give a damn what it is. Mouthwash, whatever it may be, it's not going to go well between us. Do you understand? Okay, so you get a scram today. That way we don't have to deal with the missed blows anymore. Okay?
All
right,
thank you,
Manny.
Judge. Thank you, sir.
Take a seat. We'll be with you shortly.
May I be excused, Judge?
What did you have beforehand? The date, Manny?
The date, let me take a look, Judge. Hold on.
I think he was already on board today.
Was it today?
Oh, okay. Was he already on today? I didn't know if it was just for BBRs.
Mr. McPherson, let me make something abundantly clear to you as well. I hope above all else in this short life that we have, that you are not driving. You have signed a no driving affidavit. If I find that you're driving, I'm going to go bananas on your bond. Do you understand me? I don't give a rat's behind what your excuse is. If you're driving, and whatever it may be, I hope and pray that you are not. Do you understand me? Korean's discovery complete.
Mr. It's complete on this one, and I'm making offers right now.
Okay, we're going to give you 30 days.
Okay,
At the
Judge.
end of the 30 days, he has to come back and either accept or reject the plea bargain, and then we'll just set the case for trial. But
Yes, sir. All right, I
Just way
appreciate
too
it,
much
Judge. I'm sure
drama.
Karina's going to send something very reasonable. She always does.
July 21st through the 23rd.
July 23rd. Yeah, we'll make it work.
okay, it's yours.
Thank you, Judge. May I be
Thanks, bud.
excused?
You got it. Take care.
All right.
Tell Sean hello.
I will. Bye.
Bye. Hey, you ready?
Yes, sir.
This was on the Kyra Davis. You remember she had a court setting on Monday. She had a bond violation from last week. And it was established at that court setting that she lives in Toledo, Ohio. And that was the reason why she wasn't able to make it to the
Okay.
drug testing. That was,
So we told her to go take a drug test and bring the results here.
there you go. And I have proof, it was sent to pretrial that she had taken the test, but the drug results have not come in yet.
Judge, I want to be clear, she took the test today.
Say it again?
She took the test today instead of going on the 15th right after. She took the test this morning.
That's not cool, man. Really. I mean, she's doing what the hell she wants to do.
But I think that's,
It doesn't matter. A court order is a court order. And if I continue to relent, then what happens? I'm enabling.
But I can't say on her behalf that she did take the expanded test and pay the extra money just to try to make sure anything that was suspected or.
She took the test today, and I told her if the results weren't here today, she had to be here or I would end up revoking her bond. If I don't do what I mean or don't do what I say, then no one has any gumption to follow bond conditions because they know nothing's going to happen.
Is it possible, Judge, that we see if the results can come back today? You know, I'm not saying they come back tomorrow.
But the fact remains is I told her to take a test that day, not how many days later?
2 days later, Judge.
You know,
But I think that her understanding was that she just needed to take the test by her court setting today.
no. But you told her what I said, presumably, right? That the test had to be, the results need to be here when we had court, or she had to be here.
Correct, Judge. But the test results may come back before the end of the day.
Where does she get the test done? Do you know?
I do, of course, there are not.
What do you think, Karina?
Judge, 2 days to me, they can take a detox, they can do anything in order to make sure they come out clean. She hasn't been testing in Ohio, which I know that the courthouse said as long as you go to one of the places, you can still test. Even when pretrial tried to contact her that day, she has been unresponsive with pretrial, so those are my concerns with her.
She's been unresponsive with you too?
Yeah, so I tried contacting her on the 15th. She did not return the call. I had to explain to her that she, her to contact the trial regarding the conditions that she did not respond to the call.
I'm sorry, Mr. Frank. It's too much. So I'm not going to go crazy, but I need her to understand that, you know, she's advised when you get on bond conditions, you need to remain in contact with her, with pretrial, right? And she's just completely ignoring us. I don't. Normally what I would do in this, at this time, with someone here, I would admonish them and tell them, look, not cool. I can't do that with her. So.
Well, what if I would bring her here tomorrow?
How? You're telling me she lives in another state?
I believe that it'd be more expensive for her to have to bond out and still have to fly
If
out.
I end up revoking her bond, I would do it at 2501 is what I would end up doing in it, you know, but.
She'd still have to come down here to turn herself in anyways.
Can you run her NCIC? Has she picked anything else up? Has she?
Justin, you're right on Rodriguez.
So no new law violations, Judge. The only thing she has from Ohio was cases from 2024. They just showing health. One of them is a domestic violence, just showing health from 2023. So I'm not sure what happened.
You're showing more domestic violence?
There was a domestic violence from 2023. I'm pulling up to see. Hold on, let me refresh it. It's showing that case was dismissed on 4/20/24. And then he has on May 2024, she picked up a theft and the last disposition just as held.
Here's what we're going to do. I'm going to wait till the results come in. If they are negative, I'm going to test her again randomly next week. If she ever fails to comply, remain in contact, again, I'm going to revoke her bond and I'm not going to make it just 2501. It's going to be a high bond because I've over and over. So please let her know that it's absolute no tolerance going forward. If she fails to remain in contact with pretrial, or she ever misses another test, and she's supposed to test when we tell her to test. If pretrial calls her and says you need to test on June 25 and she gets it to 26, I'm going to revoke her bond. So you need to let her know, please. Okay. So let's roll it till tomorrow just to see what the results of the test are, and we'll go from there.
Thank you very much.
Okay. But I'm not playing this game with her anymore. It's over. Yeah.
I'll make it clear to them.
Okay. Thanks, Mr. Frank.
Yeah, Judge.
Hey, what's up, Mac?
Mark,
You sure? Oh, I'm so sorry, man.
She was with the Andrade stuff, because I've been in the hospital with all of that stuff for 3 weeks.
I'm really sorry, man. That
Thanks, I
sucks.
appreciate it.
I feel your pain. So are you signing on to it?
Yeah, I mean,
Did you sign on upstairs?
I'm signing on upstairs. I just haven't had an opportunity because I've been out. This is my first kind of week back.
We're not going to do, I mean, there's nothing that we can do.
Can you sunset that term? I mean,
Oh, I don't know about that.
We're gonna wait until.
It's a DWI?
yeah.
No. I mean, if he's not done anything on it, I'm not going to do that. I mean, he just got on probation. I'm willing to extend it.
He did everything.
He was on track to do everything, but then he got kicked out on the Indy.
Has he done anything?
Mhm.
What has he done?
He's completed IFP, SOP, 2 of the 3 victim impact panels. He was enrolled, but he got arrested, in the DWI education.
He did do the DWI education, yes?
Mhm.
And he had a blower in his car, and there was never a single issue during while on bond or while on probation.
Let me see what Karina says and then we'll. So he only had one VIP left?
Mhm.
Did he ever have any hot blows?
No, he was in compliance. He didn't pay all of his fees. The only thing was the new charges that predated this.
Yeah, okay. It's not a no.
I got you.
But I have to get her position,
Yeah, sure.
see what she says, and then,
Sure.
yeah.
No words.
Andrade.
I was a DWI. I was on probation. There was a new case that.
They predate.
The DWI. He did everything that was asked of him except for one victim impact panels. He did IOP, SOP, he did no hot blows on his blower. He paid all his.
Education for us, he paid all of his fees. He even attended a residential treatment program as well, and his community service.
I'm
2 out of 3 victim impact panels. We're just wanting to terminate his probation. That's what I'm asking.
And I'm okay with it if you are. I mean, they predate, we'll just basically,
Yeah, can't find MJ anyway, so.
so,
I'm gonna get involved in.
I mean, I can't sat term him because he still has it done, but, okay.
You want to talk to somebody in the jail and give another victim impact panel?
No. I don't know about that. I don't, right. But just, we'll, yeah, we'll fill it today.
Thank you.
So, do you want me to put it as an unsat term or just this?
Did we file a motion? Do you have to file a nollie?
No, we didn't file a motion, so I can do an unsat term.
Okay, we'll just, yeah,
That way.
okay,
Thank you.
all right.
Thanks,
Well,
Judge.
good luck. Sorry about your dad, man.
Thanks, Judge. I appreciate it. So,
If you look at the screen, you see there is Miss Stacy. She's been appointed to represent you. That is your new lawyer now, ma'am. So your case is old. It's 167 days. We're going to give you one reset, but you might need to meet with the lawyer between now and then to go over all the evidence to see where we're going to start heading. We set cases for trial at 180 days. We don't just keep resetting it. Your case is what, 167, you said? So it's time to start figuring out how we're going to start heading to a completion. I'm going to have you sign a reset. You must appear at the next setting. We're going to give you a sheet of paper that has her phone number. You need to get together with her, not physically, but at least speak today at some point.
With her.
Correct.
Okay.
She's a lawyer that's been appointed to represent you. So,
30 days, Judge?
Yeah, do you want to, Stacey, you want to give me a date?
Yes, we can come back on July 2nd.
Yeah, it's up to you. Yeah, sure.
July 2nd works.
Okay, we're gonna have you sign a reset. It has her phone number on it, right?
I'll write it on there. Is discovery complete?
For the trespass, yes. And I guess Stacy and I will talk about everything else that's on the
Yeah.
office.
Okay.
Stacy, she doesn't have a phone, so I'm gonna, you give her my cell phone and let her call you from that, and so y'all can figure out how she's gonna call you again later.
Okay, sure. Thank you.
It's a 512 area code, it'll pop up on your phone.
Okay, thank you.
Okay. All right, thank you, Stacy, for coming back. Appreciate it.
Oh, no problem.
Okay.
right,
I'll,
take care.
see you tomorrow.
Okay.
Okay.
All right, thank you.
I think we're, did I need?
So this is your attorney.